At 8:12 on a Monday morning, Elena Park tried to unlock the glass door of the company she had built from scratch. Her keycard flashed red. She frowned and tried again. Red. A second later, the front desk receptionist looked up at her with the kind of expression people wear when they already know something terrible is about to happen. "Elena," Marcus said, "you are not authorized to enter." For a moment, Elena did not move. Not authorized. She had signed the first lease for that office. She had pitched the first investor. She had spent 3 years turning a failing logistics idea into a profitable California startup with 12 employees, 2 warehouse contracts, and clients across the West Coast. And now she was standing outside her own company, while her co-founder had changed the locks. Then her phone vibrated. One email, sent at 7:58 a.m. Subject of leadership. It was from Marcus Vale. Effective immediately, due to concerns regarding operational judgment and internal disruption, you are relieved of all management authority. Do not contact staff directly. Legal correspondence should be sent through counsel. Elena stared at the screen so long that the words stopped looking real. Then the receptionist quietly pushed a cardboard box toward the glass. Inside were Elena's framed photo, a coffee mug, 2 notebooks, and the blue sweater she kept on the back of her chair. That was the moment it stopped being a business dispute. It became a war. By noon, Elena had learned the full scope of what Marcus had done. Her company email had been disabled. Her payroll access was gone. The shared banking dashboard no longer recognized her credentials. Even the internal messaging platform showed her account as deactivated. But the most shocking part was this: she still owned 50% of the company. Not 10%. Not some symbolic founder equity. Half. Marcus had not bought her out. He had not dissolved the company. He had not gone to court. He had simply acted as if she no longer existed. By 3 o'clock, Elena was sitting in a downtown Los Angeles law office, across from attorney Naomi Bennett, a commercial litigator with a calm voice and a reputation for ending panic in the first 10 minutes. Naomi read the operating agreement twice, without speaking. Then she placed it gently on the desk. "He cannot just erase you," she said. Elena let out a breath. She did not realize she had been holding. "Then why does it feel like he already has?" Because Marcus had moved quickly. He had told employees that Elena was unstable, that clients needed continuity, that leadership had changed for the good of the business. By the time Elena had reached her lawyer, the story had already started spreading. Naomi began listing the options: emergency injunctive relief, demand for access to company books and records, claims for breach of fiduciary duty, possibly derivative claims, if Marcus had diverted company funds or used company control for personal gain. Elena listened carefully, but only one sentence stayed with her. "We move fast," Naomi said. Because in business cases like this, silence becomes evidence. 2 days later, they were in a California courtroom asking for a temporary restraining order. Marcus arrived in a navy suit with his lawyer, and the expression of a man who believed control was the same thing as truth. He did not look at Elena. His attorney argued that Marcus had acted to protect the company from chaos. Elena, he claimed, had become emotionally disruptive, was interfering with vendor relations, and had lost the trust of staff. Naomi stood. "What exactly is the legal basis," she asked, "for locking a 50% member out of the premises, the records, the systems, and the bank access of an active California company without court approval, without a completed removal process, and without a buyout?" Marcus's attorney shifted tone. He leaned heavily on management discretion. He suggested urgency. He used words like stability and continuity. The judge was not impressed. "What I'm asking," she said, looking directly at him, "is where in this agreement, or in California law, your client gets the right to pretend the other half-owner disappeared." The courtroom went silent. That afternoon, the judge issued a narrow but devastating temporary order. Elena was to be restored immediate access to essential company records. Neither side could remove funds outside ordinary business operations without notice. No party was allowed to interfere with the other's ownership rights until the evidentiary hearing. It was not a full victory, but it was enough to crack Marcus's story. Once Naomi obtained the internal records, the case changed. There were unexplained consulting payments. A new entity had been formed 6 weeks earlier. 2 of the company's largest clients had received emails from Marcus's personal account before Elena was ever locked out. One draft contract referenced moving profitable accounts to a new management structure. Naomi laid the documents across the conference table one by one. "He wasn't preserving the company," she said. "He was carving it out from under you." The final hearing took place 3 weeks later. By then, employees had been subpoenaed. Financial records had been organized into binders. The courtroom atmosphere felt less like a startup dispute and more like a betrayal being translated into legal language. Marcus testified first. He said he had acted for the company's survival. He said Elena had become difficult. He said clients wanted a single point of authority. He said time-sensitive decisions had forced his hand. Then Naomi stood for cross-examination. "You formed a second entity before removing Miss Park, correct?" It was exploratory. "You transferred outreach to clients before any formal vote?" "We were preparing for contingencies." "You revoked her access to company records while she remained a 50% owner?" "I believed it was necessary." Naomi stepped closer. "Necessary for the company, or necessary so she would not see what you were doing?" Marcus paused. That pause hurt him more than any answer. Then Elena took the stand. She did not perform. She did not cry on cue. She simply told the truth, in a voice that sounded steadier than she felt. She explained how the company had been built, how authority had always been shared, how no vote had removed her, how no signed amendment changed her rights, how she had been treated like an intruder in the very office she had created. Then Naomi asked the final question. "What did Marcus take from you that morning?" Eleanor looked toward the judge, then toward the empty space between the counsel tables. "Not just my office," she said. "He tried to take reality. He wanted everyone around me to act like I had never belonged there at all." That was the line people remembered. Not because it was dramatic, because it was true. When the ruling came, the judge spoke slowly, with the deliberate tone that means every word has weight. The court found that Marcus had overstepped his authority, improperly denied Elena access to company information, and acted in a manner inconsistent with the duties owed between members of the company. The court ordered full restoration of Elena's access, barred unilateral transfer of company opportunities, and set further proceedings on financial misconduct and possible damages. Marcus did not lose because he was aggressive. He lost because he confused possession with ownership. For a few weeks, he controlled the doors, the passwords, and the narrative. But in court, control is not the same as law. And law has a long memory. Elena walked out of the courthouse just before sunset. Reporters were not waiting. There was no applause, no triumphant, just a cool California evening, and the strange silence that comes after a person survives something humiliating without being destroyed by it. Naomi walked beside her down the courthouse steps. "You know what saved you?" the lawyer asked. Elena gave a tired smile. "Good records." Naomi smiled back. "And the fact that rights do not vanish just because someone louder decides they should." That may be the real lesson here. In business, some of the most dangerous thefts do not begin with missing money. They begin with exclusion, a locked account, a changed password, a door that suddenly does not. One person trying to rewrite the structure of reality before the other person can reach a courtroom. But in California, ownership still matters. So do fiduciary duties. So does the right to inspect records when you are a member of an limited liability company. And when someone in control uses that control to freeze out a co-owner for personal advantage, the court can treat that not as strategy, but as misconduct. Under California's revised Uniform Limited Liability Company Act, members have inspection rights to key company records. Controlling members owe statutory fiduciary duties, and members may bring claims on the company's behalf when wrongdoing harms the business. Because the most chilling words in a business dispute are not always "you're fired." Sometimes they are, "You don't belong here anymore." And sometimes the most powerful answer is the one Elena gave in court, without even realizing it. "I was here from the beginning.